thank you, Betsy. Betsy just broke a deal we had, which was not to go over any biography, but just to talk about law. So we'll sort that out later, Betsy. But thank you very much, and welcome and thank you from the American Society of International Law to everybody here for devoting so much time and attention to this important second set of international humanitarian law dialogues. Thanks especially, as Betsy said, to the Jackson Center and to Chautauqua and to everyone. And thank you especially, David Crane. I don't know, where's David?
Right here.
Oh, I don't have my glasses. For inviting me to speak. I really cannot express how deeply honored I am to be here. As John Barrett said this morning, there are heroes here, and I'm not that modest a person, but I'm certainly not a hero. So thank you very much. Now, I'm not going to talk about some of the things Betsy spoke about from my career, and I intend to keep my comments brief in light of the hour, and on my first reflection, my total lack of qualifications to speak on any aspect of criminal law. Now, as to briefness and brevity, I want to share with you my family standard of brevity, which I'm not going to meet tonight quite, which is this. When my daughter, who's now 20, was 2 or 3, I guess 3, and I had to take a trip from our home in The Hague to Paris, and I was concerned about her, so I phoned up and I said, "How are you? I'm in Paris. I miss you. Is everything okay?" And she said to me, "Mommy, my friend has just come over to play. Is it all right if this is a brief conversation?" You shouldn't be laughing yet. I haven't told her. And I said, of course, that's fine. And she said, "Goodbye." So, as I say, I won't quite meet that. Now, as to criminal law, my only real experience as a practicing criminal lawyer was when I was a young associate in my first law firm, which was a law firm founded by Bob Wald, who's Judge Patricia Wald's husband in Washington, D.C., and I helped a senior partner in the firm as court-appointed criminal defense lawyers to defend a young man on an appeal of a criminal conviction. I think it was for burglary. And the issues had to do with the identification in a lineup, the color of his shirt and his height or whatever, and we worked very hard, and we won the appeal, and we got him off, and I was very jubilant until my senior partner said, "But you know, of course he was completely guilty. He just had a different color shirt on." And I was so disillusioned that I stopped my criminal career right then. But to be more serious, on second and more serious reflection, my standing here tonight with you all as president of the American Society of International Law has everything to do with international criminal law. My first job out of law school was as a law clerk to Federal District Court Judge Barrington Parker Sr. in Washington, D.C. from 1977 to 79. And Judge Parker presided over a 9-month criminal jury trial for the 1976 assassination of Chilean Ambassador Orlando Letelier and Ronnie Moffett, who was his assistant at the Institute for Policy Studies. And the defendants at that trial were 3 Cuban mercenaries and an expatriate American member of Pinochet's secret police, the DINA, a man named Michael Townley, who actually placed the bomb in Letelier's car the night before the explosion. And several Chilean secret police officers were also named as defendants, but of course they were not extradited and were not in Judge Parker's courtroom. And that trial is what sparked my interest in international law and procedure, which I had not studied at the University of Chicago at all. I became interested in comparative law, treaties, extradition treaties, international relations aspects. And I must say that certain moments of that trial remain with me still, as I'm sure many of the prosecutors have memories of their trials. I remember when a very good prosecutor, Larry Barcelo, was doing a cross-examination of Michael Townley, going through routine questions, you know, what happened, what happened, what happened, and then the prosecutor said to Michael Townley, and then, do you regret, Mr. Townley, do you regret what you did? And there was silence in the courtroom, almost a gasp, before the defense attorneys could say anything. And Michael Townley, who as far as I could tell was an amoral person, said, I was a soldier, he was a soldier. That's what it was about. Miss Moffat, I'm sorry, but no. And that has stuck with me like yesterday. But no one at that time was using words like terrorism or state-sponsored terrorism. It was an assassination, a murder trial. And if anyone had told me when I was, whatever, 25 in 1978, that the DINA officers would be prosecuted and convicted by the Chilean courts in 1993 for that assassination, I would never have believed it, nor would I have believed then what subsequently developed with the Pinochet situation and compensation for the families. And to me, that's what can be the power of law, national or international. And as Ben Ferencz said today, these are my own words, but the message was, it takes time, it takes patience, but it also takes persistence and just pushing and pushing and pushing for justice. And I should also add that the assassination, the bombing took place at Sheridan Circle, which is about, I don't know, 25 yards away from our headquarters at Tiller House of the American Society. And I can't go in and out of that office without reflecting on the assassination and, less important, the impact the criminal trial had on my career in international law. And my third reflection is this, and I would be remiss if I didn't mention that a Nuremberg prosecutor also had a substantial effect on my career, and that was Bernie Meltzer, who was by far my most influential professor at the University of Chicago Law School. The subjects that Professor Meltzer taught were irrelevant, actually, although evidence was rather helpful, but labor law was not. But it was his mastery of, well, I have a job still. It was his mastery of the Socratic method that was extraordinary. Everyone thought so at Chicago. And I don't think I approach a single really hard issue in law now without a flashback to standing on my feet in Professor Meltzer's classroom and having him say, now, Miss Reed, are you sure? Are you sure that that's the right answer to that question? And if I said yes, he would say, then we have to see where that will take us. And 15 minutes later, he had illustrated whatever points he wanted to, courtesy of my answers. And it was, in fact, Professor Meltzer who suggested the topic for my law review comment, which was liberalization of the evidentiary standards for rape, which is back in 1977, and that served me well as I've watched what so many international prosecutors have done with the international crime of rape and related evidence. So I only wish Professor Meltzer, who died about a year ago, was here to see me giving this talk, and he'd be saying to me already, are you sure? Are you sure you want to say that, Ms. Reed? So as things turned out, you can guess I did not go into international criminal law, but international arbitration. And that's because, as I tell the young students who talk to me, that's where my opportunities fell in my career, largely because of the Islamic Revolution in Iran. And in my first law firm, as I mentioned, the Wald firm, we represented many claimants, U.S. nationals, mostly companies, before the Iran-U.S. Claims Tribunal, which had been set up in The Hague to resolve questions, claims of U.S. companies that had to leave Iran after the revolution. And the hostages were released, the United States unfroze the money that we had, and therefore there was a pot of money to pay claimants who could make their claims before the Iran-U.S. Claims Tribunal. And many people who still do international claims work started there in The Hague in the late 70s. So I'm going to leave aside any commercial law issues because that's not relevant to the subjects here today. What I do think is relevant, although you'll be the judge, is my work with international claims tribunals, where I've been privileged, as I say, to be both an advocate, a U.S. attorney, a judge, and a director. I'll mention some of those tribunals other than Iran as I go. And when I was thinking about what I could say to such an august group here of international criminal lawyers, with Betsy's prompting, I realized that there are some very interesting connections to what you do, what prosecutors do in international criminal cases, and what we have done in the international claims area. But I want to emphasize before I start that none of the tribunals that I'll be mentioning are genocide compensation tribunals or atrocity compensation tribunals. That is a new world, I would say. Now, in the international claims practice, which is a very small practice area, in one sense, we come at what we do the opposite from what criminal prosecutors would do. At the risk of simplifying, prosecutors' goal is to punish the perpetrators of international crimes and ideally deter future violations and ideally avoid future victims. Our goal is to compensate or otherwise directly relieve the suffering of victims of past violations, whether they're criminal or civil. But obviously we're working towards the same goal, which is bringing criminals to justice as a tribute to their victims or compensating the victims and restoring their dignity. We in my field know well from the newspapers what criminal prosecutors do and have great respect. And I would think that if you know about what international compensation tribunals do, you would have respect as well. Because the two pieces fit together. They're a synergy. And each half can magnify what the other half does. But having said that, I don't really expect that most people in this room know much about what the international compensation tribunals do, except perhaps the ICC Victims Trust Fund, which has just started up. And I don't think you should, because we're in a parallel universe. And in a nutshell, we try, in the compensation claims area, we try to obtain very small amounts of money for huge numbers of people very quickly with a low standard of proof. It's what's rough justice, the opposite of criminal justice. But what I'd like to do today is tonight is mention three characteristics that show the differences between these types of tribunals. But I'm going to give you some inside information, which is I only want you to remember one thing that I say tonight, other than my record as a criminal defense attorney, of course. And that's this. Especially I'm directing this to the prosecutors and the prosecutors to come. If you are asked to lend your support or your provenance to assist with a victim's compensation program parallel to a criminal tribunal, please don't let your colleagues reinvent the wheel. It makes me angry from my experience that this has happened too often in the various Holocaust and other tribunals. The skills that are necessary and the techniques to run an international compensation tribunal and a criminal tribunal are quite different. And I feel that the victims are disserved when the expertise is not called upon for compensation tribunals that exist. So, let me, as I say, mention just three characteristics that I think you will find interesting when you think about the difference with criminal systems. The first is this. In keeping with their civil nature, victims or claims commissions give remedies in the form of monetary compensation or asset restitution. There's no punishment going on. And commissions that award monetary compensation in particular approach remedies very differently from criminal tribunals. We group the claimants into broad classes based on a type of harm they suffered, a tort or a contract breach, say, and each member of the same class gets the same fixed amount if criteria are met. And the fixed amount is usually, shockingly, to laymen, small. Let me be let me be more concrete here. The UN Compensation Commission was set up after the first Gulf War by the United Nations. This is after Iraq's invasion of Kuwait. There, it was the United Nations that found that that Iraq violated international law by invading Kuwait, and then set up the Compensation Commission to compensate the victims with money from the Oil for Food Fund. It turned out, let's not talk about that right now. But claimants were grouped into different categories, and there was category A, those forced to flee Kuwait because of the invasion. There was category B, those who suffered personal injury or the death of a family member, and category C, those who suffered business losses less than $100,000. All of those claimants got $2,500 right up front if they could show that they fell into one of the categories. And that may seem very small. Certainly it's very small to compensate the loss of a child or a parent on the one hand. On the other hand, it's a lot for a farmer or a domestic worker who needs to reestablish their lives. But some of you may not know that the UN Compensation Commission managed and dealt with 2.6 million claims. 2.6 million cases, all but a handful of which were filed by individual human beings who suffered in the Gulf War. So only with broad classifications and small fixed-sum awards could this tribunal, if you will, avoid the Scylla of a never-ending court and the Charybdis of not having enough funds. This is an aspect of rough justice. And I want to pause here just to say that I'm really proud of this aspect of the UN Compensation Commission, because several of us who had been working for the U.S. State Department in the Legal Advisor's Office on the Iran Tribunal also helped set up the UNCC. And we had been responsible for prosecuting the claims of small U.S. claimants against Iran, individuals who had less than $250,000 damages from the Islamic Revolution. And these were people, sounds like a lot, but these were people who had left all their belongings in Iran, and many of whom were retirees who had set up some new small businesses returning to Iran from prior lives. We wanted the small claimants to go first in the Iran Tribunal, but for reasons that are too complicated to explain, those small claims ended up coming last in the Iran Tribunal. So the small people who most needed money got paid the smallest amount latest. And we were determined that wouldn't happen again after the Iraq War. So by setting up these categories and giving priority treatment to human beings, we felt we accomplished a lot of rough justice with the UNCC. Now I'll mention one more aspect of this, which is that not all of these tribunals give money. There are also real property claims commissions, post-conflict real property claims commissions that have done some very interesting work. The commission, it's a mouthful, the Commission for Real Property Claims of Displaced Persons and Refugees that was set up under the Dayton Accords to identify and return real property to claimants who'd been forced to abandon or sell their homes during the war in Bosnia and Herzegovina, was very successful. They decided over 300,000 claims. There was a court with an infrastructure, but the arbitrators also worked on foot with bulletproof vests, just going from residence to residence to residence, making awards. Now the Dayton drafters had assumed that monetary compensation would have to be given to individuals who couldn't get their homes back because it was unsafe, especially for ethnic tension still, to go back to their old neighborhoods. But instead, the Real Property Commission gave certificates showing that an individual claimant had lost a home or apartment in Bosnia or Herzegovina, in a part they couldn't go back to. And those certificates, amazing to me, became the basis for a parallel real estate market, where having the certificate would allow you to buy an equivalent home or apartment in a neighborhood where it was safe for you to live in. And hundreds of thousands of properties have changed hands in this way. And I don't think I need to tell people in this room that a secure home with a roof is an incredibly critical part of post-conflict restoration of justice and peace. So let's leave behind this question of remedies, and I'll mention a second feature of claims commissions that's distinct, and that's that they process claims with a mix of administrative and arbitration procedures using what we call a relaxed standard of proof to establish facts, especially for criminal prosecutors. And a relaxed standard of proof is needed because of the sheer number of claims that have to be processed, or because the normal evidence is missing. For example, when someone flees a conflict, do you think he or she has the title to his or her home in their back pocket or a bank book? No, they don't have that evidence. So you have relaxed standard of proof. Well, let me be concrete. In the UNCC, there was a presumption that a Category A claimant who could produce a passport or any other document showing that he or she had been in been in Kuwait before the invasion and was no longer there, was eligible for the $2,500. Perhaps more interesting here is the Claims Resolution Tribunal for Dormant Swiss Bank Accounts, the Holocaust Tribunal, where I was the co-director for the first phase, had a standard of proof, and I'm going to quote, was plausibility in light of all the circumstances. Plausibility that the claimant was entitled to a particular frozen secret bank account. And I hardly, again, need to tell this group that Holocaust victims and their heirs do not have death certificates from the concentration camps or the original bank passbooks that the Swiss banks were requiring before they would even give information about the World War II accounts. Now, the rules gave some more detail to what plausibility was in ways that would avoid fraud, but the rules explicitly talked about the expectation of destruction of such documents in World War II. And interestingly, a human nature point, there were 5,000 accounts in this first phase of the Claims Resolution Tribunal that we were trying to match for the rightful heirs. There was only one claim that was fraudulent against those accounts. There was a certain sacrosanctness of the process, which I like. Now, I should also mention that all of those accounts were not Holocaust accounts by far. They were accounts that were set up for various reasons before the war. And I would say from my personal review of a lot of files, there were a large number of French businessmen who had mistresses for whom they had to hide funds. And we, I think, surprised a lot of family members with the background to some of the bank accounts. But far more seriously, we had to deal with large numbers of claims, and I'm stressing how businesslike it is and relaxed standard of proof, but we heard a lot of stories of the Holocaust victims. And I'll come back to why I found this process frustrating in a minute. Now, and in Bosnia-Herzegovina, by the way, the claimants, the Real Property Commission, they didn't have to prove, a claimant didn't have to prove that he or she was a victim of ethnic cleansing or a causal connection between ethnic cleansing and loss of his or her home, but only that he or she had been displaced during the war. So these relaxed standards of proof are anathema to criminal prosecutors, but they're necessary and legitimate in a civil proceeding where we're focused on the fact of loss, not fault for loss, because someone else has made the decision as to who is at fault. And the last point I'll mention is this, that in these claims commissions, unlike international criminal prosecutions, we have to employ specialized methodologies to process hundreds, thousands, millions of claims. And there are mass claims techniques that have been developed since the Iran Tribunal that are like mass tort or insurance litigation in the U.S. Statistical sampling, modeling, computerized matching, standardized methods. They work like this. Say country X was trying to bring personal injury claims for 500 of its nationals before the UN Compensation Commission. They had to put in a file for each of the 500 nationals showing what had happened to those individual people, what kind of injury, where they were hospitalized, etc. The commission only had time to sample. Maybe the commission would look at, I don't know how many, 20 or 50 of the 500. And if on the basis of those 20 or 50, only 40% of the files showed that kind of injury, all 500 claimants would only get 40% of what they were being asked. It's a mechanism to control abuse of the system that works quite well, but doesn't work well in criminal proceedings, obviously. But it's how you get the neediest victims, as I say, a small amount of money quickly. Now, as I say, this isn't just a bloodless, mechanical, computer geek operation. We read lots of stories, and I have many memories, I won't go into, of the stories from the claims resolution tribunal, particularly children who were finally getting access to the bank accounts and the property of parents and grandparents that the Swiss banks had denied had ever been put into the Swiss bank system. And certainly now at the Eritrea-Ethiopia Claims Commission, where we are reading and hearing victims' testimony from the border war, a lot is personal stories. So I'm going to tell you just a bit about that commission because not much is written about it, but it's particularly interesting for this audience. I sit as one of 5 commissioners. The others, some of you may know, George Aldrich, who's on the Iran-U.S. Claims Tribunal and was a drafter of Geneva Protocol 1. John Crook also had been an agent at the Iran Tribunal and knows a lot of military law from his work in the Sinai. Jim Paul, a human rights lawyer who had been at Rutgers and was the first dean of the Haile Selassie Law School in Ethiopia at the time, and Hans von Hütte, who is an arbitrator on both the Claims Resolution Tribunal and the Bosnia Real Property Commission. So this is to emphasize there's a small number of people who work in this area with expertise. We are the first and only international tribunal set up to resolve civil liability for violations of international humanitarian law. And I emphasize international humanitarian law because Eritrea had not signed the Geneva Conventions before the end of the war. So one of our tasks was to look at which aspects of the Geneva Conventions are customary international law and which aspects of Protocol 1 have become customary international law. And for that reason alone, it's worth, I think, reading some of our liability decisions. And so what we've been doing is looking for violations of the Genevas and international humanitarian law during the boundary war between those two countries that ended with a peace agreement in 2000. Now, Eritrea and Ethiopia chose not to do a mass claims process and allow their civilians to have their own claims and use all these techniques I've just talked to you about. Instead, the governments are filing on behalf of their civilian victims of different humanitarian law violations, prisoners of war, expellees, rape victims, property owners, etc. So we've been using some of the techniques, particularly as we get into damages. And what the Commission has found, and I can only describe it, I can't comment on it since I'm a commissioner, we have found each government liable for taking acts in violation of humanitarian law or refusing or not preventing acts in violation of humanitarian law by their troops and civilians that involve mistreatment of POWs and detainees, physical and mental abuse, nothing approaching genocide, by the way. And with the prisoners of war, we made a specific finding that there were prisoners of war, that very few soldiers were killed, wounded soldiers were killed on the battlefield. There was forced labor and sporadic, I'm happy to say only sporadic instances of rape, certainly not rape as a weapon in that war. A lot of property destruction, violations of diplomatic privileges and immunities. And a lot of scholars are paying attention to the fact that we found Eritrea violated the jus ad bellum in its original invasion of Ethiopia in violation of the UN Charter. So people are looking at the awards on liability. We are now, they're all on the Permanent Court of Arbitration website, by the way. We are now in the damages phase. We're deliberating damages amounts. We're trying to do the math and put numbers on the value of these violations of international humanitarian law. Despite our efforts, and I feel comfortable saying this publicly, despite our efforts to steer the governments of Eritrea and Ethiopia away from the damages phase, more to a just satisfaction or truth and reconciliation process, they wanted to go to damages. We've had 2 hearings. We're doing that now. So if any of you in this room ever wondered what the maths would be, what countries might claim for violations of the Geneva Conventions in the course of a war, I can tell you that these 2 very, very poor countries are claiming many, many, many billions of dollars from each other for the harm that was inflicted on them and their civilians during quite a short but destructive war. And even with the exaggeration that's inherent in any process like this, certainly this proves the truism that the cost of a war on the civilians and the post-war damage that has to be taken care of vastly, vastly, vastly exceeds the cost of fighting the war. Now, I'm not going to go into any more characteristics. I do want to mention briefly that I am of the view, having worked on a lot of claims commissions, that criminal prosecution and victims' compensation should be separate. They should be kept separate. That's the conventional wisdom, and I share it. That's been criticized by commentators who have value judgments about one or the other. And I know at the ICTY there was consideration in the 1990s about, under international pressure, about amending the authorizing statutes so they could award compensation to victims. And the ICTY Rules Committee decided not to because it would lead to incentives for shorter trials, put more pressure on the prosecutors, on their workload, and undermine the legitimacy of their convictions and cost a lot of money. The better approach, said the ITCY, would be to establish a separate International Claims Commission parallel to the tribunal. And that is what the drafters of the Rome Convention, as you know, have done. So instead of appending a compensatory function on the court, there's a separate institution, the Trust Fund for Victims, that's supposed to advocate and help the victims of genocide and the other crimes. And the Trust Fund was started up in 2006 and is effectively independent and busy with some operations, I know, in Uganda and the Congo. It's early days for the Victims Trust Fund at the ICC, which it has very limited resources. As I mentioned, the Iran Tribunal had frozen assets to spend. Claims Resolution Tribunal had old bank accounts to spend. There has to be a source of money to make these commissions worth doing. But I certainly am watching the trust fund carefully, and others are. I have concerns, frankly, about the idea of mixing witness testimony with compensation for witnesses. But I like to think people who are working on that, who know more than I do, have thought that through. But I do know this. I don't consider it an impossible dream. I really don't. That convicted war criminals of this day and age who have stolen billions of dollars and hidden billions of dollars from diamond trade or slavery or whatever may one day have those assets be uncovered somewhere and used to be applied to victims' rights. I didn't think Letelier would lead to justice against Pinochet regime, and it did, and I certainly didn't think that the Swiss bank accounts would ever be uncovered for Holocaust victims, and they were. So I have a certain amount of optimism that this should remain in our sight. Now, I come to my plea that I mentioned in the introduction to end this talk, and that's this. I expect that criminal prosecutors are or will be approached to set up or support victims' compensation programs because you're so visible and you're well placed to help the victims when you're prosecuting the perpetrators. And so in the spirit of the dialogues, the international humanitarian law dialogues, which are to share lessons and strengthen one tribunal to another, one prosecutor to another, I want to share one of my greatest frustrations in this aspect of my career, claims commissions, and that's this. People who come up with the idea of a claims commission, or certainly a victims claim commission, for which they deserve a great deal of credit, also want to start it. They want to write the rules, they want to draft the claim forms, they want to set up the systems, they want to do the computers, etc. They feel entitled to own it, and they make a lot of mistakes. I've written about the procedural shortcomings of the Holocaust, the Swiss bank account tribunal. Anyone here will recognize why I was unhappy. The claims forms were written and published around the world in such a way that there was no field for age. So there was no way to sort through those thousands of claim forms to find the oldest potential Holocaust victims and give them priority treatment. And a number of claimants in their 90s died before we could find their forms and deal with their claims. In that tribunal, the Swiss banks were allowed to control the budget on a monthly basis. So they could exert pressure when they didn't like a decision in favor of a certain category of claimant. They would threaten to withhold funds. Doesn't make sense. The claimants had no ombudsman in the Holocaust Bank Tribunal. So the World Jewish Congress and Paul Volcker did a great job setting it all up, but then they moved on to their next tribunal, I think the Insurance Tribunal, and there was a staff of young lawyers trying to help arbitrators award funds, and all these claimants around the world, mostly aged, with no one to help them. They're not allowed to have lawyers. There was not even $100,000 spent on an ombudsman's office to help them. And I just would hate to see, I hate it when this happens. So I, as a pro bono matter, went to the people setting up the next Holocaust Tribunal and said, I'll help you. I'll tell you how to do this. I'll help you with the claims forms. And they said, no, thank you. We started it ourselves. We want to run it. And they made a lot of the same mistakes. So here's my plea. If you are asked to help support a genocide or a victim's claims compensation program, be aware there's expertise. There's expertise at the Permanent Court of Arbitration. There's particular expertise at the International Organization of Migration in Geneva, where they've run the German Forced Labor Compensation Program, Holocaust Victim Assets Program, the Iraq Property Claims Program, and many others. They have practice guides. They have people, including Norbert Wöhler, who's the head, who I know from Iran days and UNCC days, and they're willing to help. They're anxious to help. The victims really deserve getting expertise rather than well-meaning new institutions. So, as my daughter would say, it's time to say goodbye. It's been a long and productive day. There's another one tomorrow. And I just hope I've left, especially the prosecutors, with some interesting or useful information. If you are asked, or you have to, by choice or necessity, step into the incredibly important role of trying to bring money or bring homes or bring symbolic recognition. Often it's only going to be symbolic recognition to the victims of the horrific crimes with which you are dealing. And if Bernie Meltzer were here, he would say, are you sure you've said everything you want to say? And the answer is no, but I've said everything I think that I need you to hear, which is call me or call Norbert Wöhler or call someone if you're in this situation. Thank you.
Thank you, Lucy, for that extremely insightful speech. Tomorrow, the activities are here at the Athenaeum, so don't go to Fletcher. Breakfast will start at 7:30 tomorrow. We'll have a presentation by Michael Newton at 9 o'clock. 10:30 will be Nuremberg and Genocide, an Historical Perspective, moderated by John Barrett, Whitney Harris, Henry King, and Ben Ferencz. We're also going to have the luncheon presentation by Grace Acalo. We look forward to that. And then the issuance of the second Chautauqua Declaration at 2 o'clock, hosted by one Betsy Anderson. We look forward to an extraordinary day tomorrow, as it has been an extraordinary day today. Thank you, everybody. Have a good evening.
Okay, ladies and gentlemen.